Melvin, thanks for coming.
Good evening, everybody. I am an attorney. I do civil rights litigation. What little bit there is here in Roanoke and in Virginia and in the Fourth Circuit. If you know anything about the legal environment in which we live, it's not real positive towards individual rights. The Fourth Circuit, Virginia courts give a lot of deference to law enforcement, to government officials. They get the benefit of the doubt, they get the breaks, they get the second guesses on everything. So it's very difficult to litigate cases. In fact, I was at a civil rights seminar back in March, and they were talking about these huge cases, inmate lawsuits where inmates are being tased while they're secured and restrained. Things just crazy stuff, and they're getting $1 million settlements. I'm kind of like, in Virginia, that's just no big deal. An inmate's not going to get millions of dollars out of something like that. Not in Virginia. It's not going to happen. I litigated a case back in January over here at the Pop Building, federal court. An inmate was on the farm crew at Camp 25, the Botetourt Correctional Center up in Botetourt, that's now closed. Has been under federal investigation for embezzlement, pilfering of state goods, inmate abuses. And I had one of those inmates come to me and said, this is what's been happening to me while I've been working on the farm crew. Because the Botetourt Correctional Center actually is a 96-acre working farm. They had cattle, they had grazing land, they had a shop, they did work on VDOT vehicles. It was a working place. You could live out there like you're living on a farm. Well, this fellow came to the Botetourt Correctional Center out of Allegheny County, had a drinking problem. And when you get up to about your third or fourth DUI, you tend to do penitentiary time for that. And he was. He was going about 3 years in the penitentiary. And got assigned to Botetourt Correctional Center, but he was a very good welder. He worked at Midwest Vaco as a welder for years before he got laid off. Just was an excellent welder. So they put him in the shop, working on the farm crew, doing whatever welding needs might have. He would work on blades for snow plows from VDOT. He'd fix dump trucks. He'd weld certain things. As time went by, he started welding various things like hangers for hanging deer to skin, like scalding pots for pigs. And you might ask, well, what's that got to do with the Department of Corrections or VDOT? It doesn't. He was making these for individual correctional officers or VDOT employees. They were either taking it, using it, selling it, giving it away, all of course with state materials. That's part of what this investigation is about, that at least the U.S. Attorney's Office, as far as I know, is still investigating now about 3 years later. They haven't indicted anybody or anything like that. But this guy also became the butt of the jokes in the shop and on the farm crew. He would be welding, and if you know anything about welding, you wear a big hood with a very heavily tinted glass because the arc that you make with welding can burn your eyes. He'd have his welding hood on, he'd be bent over working on material. Various things would happen. The correctional officer was the supervisor over the farm crew. At times would come up and he would be wearing these dungarees, these blue jeans that the Department of Corrections issued. And when you lean over, the pockets would kind of gap. You'd have a little opening there. Well, the correctional officer would walk by and he'd drop a lit cigarette into the pants pocket. And as it would burn through the pocket. He actually had scars on his buttocks from where a number of these cigarettes had burned through his pants. And we had a guy who came to trial who he was the manager of the warehouse at Camp 25. He said, yeah, this guy came up any number of times and he would trade in pants that had holes burned in them. He said, I didn't think anything about it because he was a welder and that just happens. He never thought about, you probably don't get welding holes in the rear pants pocket on a welder. You get them on the front. Other things that would happen. One time, your welders are often electrical welder, depending on what kind of gas or electrical. The supervisor, the correctional officer, he would rig up the plugs, two 20-volt plugs, if you know anything about electricity. As this guy would go to plug it in, there'd be a wire sticking out of the plug, and it would cause an arc, a spark. Maybe the guy think he was being electrocuted as he went to plug in the welder. And he said he would get soot and burn marks on his hand from where he'd go to plug in the welder and it would arc. Other time, he was working underneath a vehicle and was welding a piece of equipment underneath the vehicle. The correction officer walked by and threw a pack of firecrackers underneath the car. Of course, he's working underneath a dump truck near the gas tank with a welder, and he hears boom, boom, boom. He said, I was scared and I thought the truck was blowing up because I've got something too hot and ignited the fuel. Scared him half to death. Another time, he was working underneath a vehicle and he was pulling out a bolt, and the bolt broke, and the wrench came back and cracked him in the lip, and basically the tooth went through his lip. Correction officer watches and says, "Let me see that lip. What's that look like?" Takes and sticks a habanero pepper down in the cut. And stuff that you might think is just stupid pranks, and then I'll get a good laugh out of it, have a good time. But this guy, he's captive there in prison. He can't do anything about it. So we filed a lawsuit alleging that it was cruel and unusual punishment for these actions, these various things. We got all the way to trial on it, and a jury apparently didn't think it was bad enough to do anything about it, because they found for the correction officer, said there was no violation of his 8th Amendment right to be free from cruel and unusual punishment. So that's just the type of atmosphere we have in Virginia. A lot of people think inmates are second-class citizens, not entitled to any rights, things like that. Consequently, I'll be very hesitant to file my next inmate lawsuit. But as an attorney, I don't want to file lawsuits that I don't think are going to go anywhere or be any benefit to anybody. But that's just one example of the type of environment we get in. And even to get that case to trial was about a 1.5 year legal battle just to get to trial. Because the defendants in that case fought tooth and nail every step of the way to get it just thrown out without even having a trial. And then we were fortunate enough to even get to trial. And the judge in that case, who was Judge Glenn Conrad, he's a United States District Court judge. He was a magistrate judge for about 25 years before he went on to the district court. And he said it was a close call. Even accepting all of the plaintiff's complaints is true. All of these things that had occurred to him, even accepting those as true, it was a close call whether we even got a right to go to trial. We almost got summary judgment in favor of the defendants in that case, but it did make it to trial. And you'll find that is all too frequently the way cases are disposed of when it comes to civil rights matters. The way a civil rights lawsuit generally begins, obviously the police or some type of government official does something that is at least questionable, if not outright wrong, in violation of the Constitution. Somebody's going to come to me and they're going to complain about it. And I'll tell them 9 times out of 10, there's nothing I can do to help. I had a lady came to me today. She said apparently her son is involved somehow with social services. They're providing services to her 15-year-old son. One day, a social services worker who is her son's assigned counselor picked her son up from school and took him to be evaluated by a counselor to determine whether he was suicidal. Whether he was suicidal or whether he would be at risk of harming someone else. Which, if you know about the temporary detention process, mental health commitments, that sort of thing, this is what that process is all about. Is someone at risk of harm to themselves or others. The mother never said that could happen. The mother never gave permission to have her son taken and evaluated to see if he was suicidal or a threat to others. This 15-year-old boy who I met him, and he probably has a mentality of maybe about a 9-year-old. He's not at the upper end of the intelligence scale. He became very upset because he ends up being evaluated for suicide or risk of harm to others. Then he ends up at the emergency room at Creamer Memorial Hospital. He's getting more and more agitated. Where's my mother? What's going on? I don't want to be here. Why are they asking me these questions? I didn't do anything wrong. Korean calls in security officers to guard him. The boy tries to run at one point, and the officers physically stop him from leaving and drag him back into the ER, basically. Mom finally is called, rushes over to the hospital. She practically has a conniption fit. What are you doing with my son? I didn't tell you could do this. I don't want him here. He's not suicidal. He's not going to hurt anybody. But because of the way our mental health laws are, the boy ended up staying at the rehab center at Brilliant for a week. This was back in March. And I just said, ma'am, I believe that social services overstepped its bounds, violated your parental rights, but this is not a case I'm willing to do anything with. It's not severe enough. It's not bad enough. In the eyes of the law, that is something that I think you should invest your resources, because to litigate a case in federal court before you even pay any lawyers, just the cost of the litigation, you're probably looking at $15,000 to $30,000. And I know this lady didn't have that kind of money. There's no way she had that kind of money. But to take any number of depositions, to just file the case in court, to get to trial, you're looking at several $1,000s. I said, I think your son's rights were violated, your rights were violated, but I think you just need to move on. And that's what I tell most people who come to me with a civil rights violation, if I think there's a violation at all. A lot of people just want to complain. But now those cases that make it to the next step where I say, you know what, this is something that I think is worth pursuing. This is an egregious enough violation. I have begun using with great frequency Freedom of Information Act requests. I had a guy last week, about 2 weeks ago actually, called me, and he said, my son got involved in a high-speed chase in Montgomery County. The officers finally stopped him down on 460 near Shawsville, and as they got him out of the car, they beat him. And glory be, there's a videotape, because so many police cars now, they have the cameras mounted in the windshield. There's a videotape you can see when the officers get out, they beat on him. I said, all right, let's see if we can get the copy of the videotape. I sent a Freedom of Information Act request to the sheriff of Montgomery County, and he sent me the tape. I was thrilled. I got the CD, actually DVD I guess it was, put it in, started watching it. The only bad thing about it is apparently at some point this guy was driving a minivan running from the police. At some point, the minivan started spewing something. Something broke. So the windshield of the police car that's got the camera, it becomes very hazy. You can tell that the windshield just gets splattered with something, and the officer turns on his windshield wipers, and it just smears everything. So it's not a real clear video. Another police car is able to get in front of this guy, and they do a moving stop on him. They get him stopped. One officer comes up, gun behind him, runs down the car, opens up the door, then begins yanking on the guy. Now, I talked to the guy's father, they asked, yeah, they began yanking on him because he had a seatbelt on. You're trying to pull him out of the car, he's still got a seatbelt on. So you can see the officer kind of reach around him, and he gets the seatbelt unbuckled, pull him out, throw him to the ground, and it does look like there are a couple punches thrown in. There was one officer, I think there were at least 3, maybe 4 officers. Somebody came up, probably kicked him once. So it was probably an excessive case where the officers used too much force to gain control of the subject. Probably. But then I looked up the guy's criminal history. His criminal history in Montgomery County alone takes up about 3 pages on my computer screen. And it's about anything you can think of. I mean, out of this charge alone, he got felony eluding police and every traffic infraction you can expect. He was driving suspended. That's why he ran from the police in the first place. And I said, you know what? This guy's going to have no sympathy in front of a jury. It's not worth it. Don't bother. And from an attorney, from a business standpoint, that's the right decision. From a standpoint of holding the police accountable, it's a terrible decision. It's a sad thing, because the next time the police gets to do that again, nobody did anything about it. They're emboldened. The next time, maybe instead of 2 or 3 punches, it's 5 or 6 punches or 10 or 12 punches. Maybe next time they pull out their gun and they shoot the guy. But the reality of litigation in Virginia and in our federal courts in the Fourth Circuit, Court of Appeals, is that you got to have a really good case. Now, we did have a pretty good case this week that went to trial. A guy who was a taxi cab driver in the city of Roanoke. And back in January of 2008, he picks up a lady at Valley View Mall at the Walmart. Now, why this lady is at Valley View Mall at the Walmart at midnight with the 2-year-old is beyond me. But she needed a taxi cab to drive her home at midnight with her 2-year-old. I think actually it was her 2-year-old grandchild.